I need the white book? I forgot to bring it with me. No, okay. I said I would. And then God, I'm so sorry.
Mr. Kennedy.
My lords, if I may go back to ground one for a moment, because over the lunch and adjournment I was thinking about an answer to my lord's questions about examples of how prejudice can arise on this particular case, if that's the proper approach. And may I briefly show you how that can happen by reference to this particular case, and ask you to go back to the master particulars of claim in the core bundle behind tab 25. And if you go to page 383, you will see at paragraph 2 a reference to cease and desist agreements entered into between the defendants and the Brazilian Competition Authority. Paragraph 2 says, following complex administrative antitrust proceedings lasting more than 18 years, the relevant authority, which we shall call CADE, determined in 2018 that the evidence unequivocally proved the existence of the cartel. But I rely and refer to the next sentence. In November 2016, certain orange juice processors, including Suco Citrico and various individuals, including the second defendant, entered into cease and desist agreements with CADE, and then this, by which they confessed their participation in the cartel, as well as undertaking to pay financial penalties and cease illicit conduct. Pausing there, the defendants obviously deny that they confessed to any illicit conduct, but the fact of the cease and desist agreements and the fact that they were entered into is admitted, as I shall show you in a moment. These cease and desist agreements, by which the claimants say the defendants confessed the unlawful conduct, were published, and the claimants plead that themselves on page 395 of this same bundle, within the master particulars of claim. Paragraph 39. CADE's administrative tribunal proceeded to ratify the cease and desist agreements on the 23rd of November 2016, reference to which was published in the official journal of the Federal Government of Brazil on the 29th of November 2016, while a judgment certificate dated 28th of November 2016 was published in the official journal on 9th of December 2016.
Now you say this is exactly within the zone.
Yes, because if a 3-year limitation period runs from November 2016, it doesn't knock out the first set of amendments, but it does knock out the second set of amendments. The second set with the 23rd of January 2020. Now, that's not to say we accept that on the basis of when relevant knowledge was acquired, a limitation could be found to cease earlier, much earlier. But this is squarely on the claimant's pleaded case that these alleged confessions were published in November 2016. And it's common ground, as I said, that Brazilian law is the applicable law for limitation. And moving on to the defense, just to recall, the defense on tab 26, page 439, please. 439. Paragraph 45. I should have asked the court to note that the paragraph we've just been looking at was paragraph 39 of the particulars, and the first sentence, the fact of the publication, the fact of the cease and desist agreements and their publication is admitted by the defendants, that they were published in November 2016. And in the reply, in the claimant's reply, paragraph 27, that's on page 476 behind tab, so tab 27, page 476. The claimants meet our case on knowledge, paragraph 27. Their pleaded case is that the earliest possible date is the 8th of March 2018. But below that, 27.1, they refer to protests filed by the claimants before Brazilian courts, which claim that the limitation period had restarted, a technical device whereby a limitation period can be restarted under Brazilian law. Those protests, or protestos in Portuguese, are pleaded at paragraph 27.1. And we wrote to the claimants and asked them for examples of these protestos to see what they said. And we have an example in the supplemental bundle. If you go to tab 37 of the supplemental bundle, tab 37 is the letter from the claimant solicitors, Bogus Goodhead, dated the 12th of May 2023. And you see in the covering letter, they enclose a sample, this is paragraph 2, a sample protesto translated into English for us to review. The protesto begins in translation on page 622. And if you go ahead, please, to page 629, you see what was pleaded in the protesto before the Brazilian courts in relation to limitation. On page 629, paragraph 14, the claimants plead the starting point for calculating the limitation period, given the date when facts were reported, is the 28th of February 2018, the date in which Clare published the closure of administrative cases, which is the same as their pleaded case in England. On this occasion, one must mention that even if another date is accepted, the homologation of the 7 TCCs, those are the cease and desist agreements, for example, which occurred on the 23rd of November 2016, the truth is the claimant's interest in suspending the limitation period is still unchallenged, given this measure is mandatory. So here we have an example of a claimant in Brazil accepting that, the possibility at least, that time began to run when the cease and desist agreements were ratified and published on the 23rd of November 2016. The publication date was a couple of days later. But to be clear, it's the existence of the cease and desist agreements that was published, not the content. The content of the cease and desist agreements was not published, but it's the existence that was published. And that is an example of how in a pleaded case, one could well end up with a limitation period expiring between the first and second set of proposed amendments. Moving on then to the second ground and relief from sanctions. Again, I reflected on the questions put to me by Rhodas Lewis over the adjournment. The question of what happens when the box is ticked on the acknowledgement of service, but no application is made. And that's a point which hadn't come up below or in the submissions between the parties. The better answer may well be that in those circumstances, if the party does not pursue the jurisdiction application, then this 14-day extension should not apply. The implicit 14-day extension for which we contend should not apply in those circumstances. So to be clear, it should apply where the jurisdiction application is made, and it runs from the resolution of that application, the final resolution. But where the box is ticked and no application is made at all, then the applicant does not get the benefit of the 14-day extension for an application under 17.2.2. In those circumstances, the applicant will need to apply for an extension of time to make their application under Rule 17.2.2, and presumably, by way of justification, explain that they were considering but decided against a jurisdiction challenge. that approach would more effectively address the uncertainty concern, which was put to me by my Lord Justice Lewis. So that's my submission on that point. Moving on, if I may, then to implied sanctions, and the court, as you have seen, proceeded on the basis that there was an implied sanction, and the claimants say that because an application cannot be pursued if it is not issued in time, that is all that's required. That is the sanction. But that is not, in our submission, the current law. And I'll begin with Sanches and the Secretary of State for the Home Department, upon which the claimants do rely. And that's in the second volume of authorities, tab 31. And of course, we're discussing implied sanctions because there is no express sanction within Rule 17.2. Sanches is, as I said, behind tab 31 in the second volume of authorities. And the head note on page 818 describes an application under Rule 3.12a for an extension of time pursuant to Rule 52.4 for filing a notice of appeal. So it was a late notice of appeal. And if you go please to page 827, paragraph 34, Lord Justice Moulder mentions the Altomar case, which concerns an application for an extension of time in which to file a respondent's notice. And skipping down to the bottom of that paragraph 34, he says, I express the view that it was now established that an application for permission to appeal out of time is analogous to an application under Rule 3.9 for sanctions, and therefore is to be decided in accordance with the same principles. And then skipping down to paragraph 36, beginning, if I may, on the second line at the end, as the authorities demonstrate, for the past 12 years, it's been consistently understood. In the Sayers case, this court deliberately equated applications for extensions of time for filing a notice of appeal with applications for relief from sanctions, because in its view, the implied sanction of the loss of the right to pursue an appeal meant that the two were analogous. And that's relied upon against me to say that's a general application. But in this case, it was applied only to an application for extension of time for the notice of appeal, and Lord Justice Moulder did not say this was a principle of general application. He applied it by reference to the approach that had been taken for respondents' notice. This the suggestion that it applied whenever a step could not be taken in the absence of an extension was deprecated in Lufthansa, a later authority, volume 4, behind tab 58. Lufthansa technique begins on page 1567. I'll ask you to go directly to page 1570. Paragraph 2. Lord Justice Burse, the issue was that Lufthansa was a claimant in a patent action. You see in paragraph 2, the court dismissed an appeal about 4 lines down, in which the learned judge found the patent valid and infringed by the defendant Panasonic's products. And an order was made, dated 22nd of July 2020, requiring Panasonic to provide information about their sales revenue for the relevant infringing goods, along with information about the costs. And this type of order was designed, keep reading, to allow the patentee Lufthansa to elect between pursuing an inquiry into damages or an account of profits. That was the purpose of the information to be provided, and the order was made on the 22nd of July 2020. Go to paragraph 4 of the page. The deadline for compliance with the order was the 30th of October 2020. It had to be provided in a witness statement supported by a statement of truth. in paragraph 6, and it was done by that deadline. But on the 22nd of September 2022, so nearly 2 years later, after the election had been made, Panasonic solicitors told Lufthansa solicitors there were going to be updates, and on the 2nd of December 2022, more than 2 years later, they served a witness statement with different figures. And if you see the bottom of paragraph 6, the overall effect of this is to reduce the profits that the victim Lufthansa can claim by about $30 million. Now, initially, the defendants in this case, Lufthansa accepted they needed relief from sanctions, then they changed tack. And if you go to paragraph 19 on page 1574, the issue became whether there was an implied sanction and relief from sanctions applied at all. In paragraph 21, Lord Burst analyses relief from sanctions and says these rules don't create sanctions, Rule 3.8 and 3.9, but apply when a sanction exists. Rule 3.8 operates to make clear that when a sanction is provided for, there is no need to come back to the court for an order imposing it. Skipping down, Rule 3.9 provides for the principles to be applied in applications for relief from sanctions. The sanction may be expressly provided for, in which case no difficulty arises, but there are also cases, like in Altamort, quoting Lord Morbic, the courts have recognised the existence of implied sanctions capable of engaging the approach contained in Rule 3.9 and the Denton principles. And over the page, the idea in Sayers, still at the bottom of 1574, is that although the rule provided for the time limit has no express sanction, it's implicit that without the extension of time, the appeal could not be brought, which amounts to a sanction. And that was applied to respondents' notice. And 22, many kinds of applications for an extension of time in case of breach do amount to an application for relief from sanctions, such as application for extension having failed to serve witness statements, similarly an application to set aside default judgment. However, between B and C, it does not follow that breach of any rule, practice, direction, or order which requires something to be done within a certain time necessarily requires a relief from sanctions application. Skipping down between C and D, simply because a rule, practice, direction, or order uses the word must, does not on its own engage the relief from sanctions doctrine. As Mr. Justice Martin Spencer observed, one needs to look at what the default position would be if no extension of time were granted. If a sanction is in effect as a result of the express terms of a rule, relief is required, if not, not. And still in that judgment, so that was the approach set out by Lord Burst, and it was not, on any view, an open door for creating new categories of implied sanctions. And we see that in the yes judgment.
Has he said that yet? I mean, at the moment, all the 22 says is that it's not as easy as it looks. But where does he say? And there are cases where an extension of time for doing something, it's just implicit, is it, in 22?
Perhaps the next judgment is clearer,
okay.
Because this judgment is relied on in yes, and I'll take you to the next authority, or it's set out more clearly. That's behind tab 59. It begins at page 1582, and if you go to page 1584, you see at paragraph 1. This time it concerns the question whether a late application for permission to rely on an expert report in a new discipline not addressed by the existing directions required relief from sanctions. And of course, if relief from sanctions doesn't apply, the court, it's not just waved through. The court then asks under the overriding objective in part 3 of the CPR whether it ought to be permitted. Page 1588, please. Relief from sanctions is addressed from paragraph 24, just the heading. And if you go on, please, to page 1590. He recalls, the learned judge recalls what he said in Lufthansa in paragraph 26, that they don't create sanctions but apply when a sanction exists. And paragraph 27, he refers to the Master's Roles analysis in BXF. Skipping down 3 categories of case where the order or rule expressly provides for the sanction that will apply. Little 2, Roman 2, cases where the rule does not expressly state the sanction, but permission of the court is needed. failure to file a notice of appeal on time is an example. In cases where a further step is taken in consequence of non-compliance. 60, in the indented passage, the law as stated in Denton applies directly to the first category, and Sayers, Ultimatum, Heisage make clear that despite Matthew's applications for extensions of time to file a notice of appeal, an instance of so-called implied sanctions should be approached in the same way as applications for relief from sanctions and attract the same rigorous approach. And he says at 28, the circumstances in the XF were the third category, however, the present case engaged the second category. In other words, this appeal is about implied sanctions. And then over the page is to paragraph 31. Bear in mind the importance of clarity in the procedural framework to be followed by court users. The hurdle for identifying something as an unexpressed but implicit sanction must be a high one. It has been identified in the two circumstances mentioned in the cases above. I prefer to say the scope for identifying any further implied sanctions over and above these two must be very narrow. Bearing in mind that the Denton ethos may apply even when Rule 3.9 is not engaged. The need for further extensions of this concept is likely to be very limited. So in approaching applications even under the CPR Rule 3 and the overriding objective, the general ethos of discipline should apply. Then at paragraph 33, over the page 1592, in summary, in my judgment, the general approach to working out whether a case is covered by Rule 3.9 is to start by identifying if a rule, practice, direction, or order has been breached. If there is none, then the rule does not apply. If there is a breach, then the next task is to identify any sanction for that breach expressly provided for. If there's no such express sanction, then outside the third category identified in DXF and the specific recognized instances of implied sanctions identified in Sayers Altamont, i.e., not e.g., notices of appeal and respondents' notices, there is no relevant sanction for the purposes of Rule 3.9, and so that rule does not apply. And we rely upon this judgment as authority for the very strict approach which the court should take to relief from sanctions. And here there is no basis for saying there's an implied sanction, and the court erred in assuming that simply because without permission it couldn't make the application, without the extension of time it could make the application, that was the sanction, that was all that was required. And that, in our respectful submission, was an error. And the consequence is that this court is in a position authoritatively to address the relevant question, which is under Rule 3.12a and the overriding objective, should we have an extension of time retrospectively for the purposes of our application under Rule 17.2 sub 2. And so I address you now briefly on why this court should exercise your discretion under CPR Part 3 to give us the extension. The first point is that we were challenging, the defendants were challenging the jurisdiction of the English court. And a strikeout application, even with a proviso, may have amounted to a voluntary submission to jurisdiction. This is an explanation for why we did not, the judge is right, to issue the application on time. And a voluntary submission to jurisdiction would have involved very substantial prejudice to the defendants.
But even if not, you might want to say it's sensible to get jurisdiction sorted rather than run up costs and have additional things. So even if you might have avoided it, it is not still a factor, perhaps a less powerful factor, if you wait to sort out jurisdiction.
The first point is, if the deadline was 14 days from 17.22, did we have a good reason for missing that deadline? And our reason was that we were concerned that we might be submitting voluntarily to
I
jurisdiction.
understand that, that's your headline point, but even if that wasn't the case, if you had a more robust claimant, or defendant in your case, the fact that you're sorting out jurisdiction first may be said to be a good reason, because arguably it makes sense to see if the court's got jurisdiction at all before you often have arguments about extensions of time.
Yes, but yes, indeed. And as I misunderstood, that's a reason why a good reason for why we ought to be allowed, why extensions ought to be allowed in order to make sure that's done. And of course, the prejudice of inadvertent submission is very substantial. But if we are denied the extension of time, let's assume we're denied the extension of time and therefore not allowed to make the application under 17.22, we lose the opportunity to strike out 1,361 claims. It's very serious. And even if they were reissued, we would have, on our case, a stronger limitation argument to make against those claims in reissued form. Just taking you to the judgment, how the learned judge addressed our points and the questions of prejudice. It's in the core bond on tab 15, page 233. Judge dismissed the prejudice to us on the affectionate basis for the same reason for dismissing our arguments on running a jurisdiction case in parallel with an application of 17.22. Focusing on prejudice to the claimants, paragraph 133, she says the prejudice arises not as a result of the defendants exercising their right to challenge the amendments, but by reason of the way the application has been pursued. And she cites Chandra, but Chandra here is interesting because one sees in the first sentence of Chandra cited, the claimant applies for permission to amend, and the amendment arguably adds a new claim which is statute bar. The claimant should take steps to protect itself. The onus is on the claimant to take steps to protect itself when there might be an argument that this new claim is out of time. So it's not for the defendants to warn the claimants. The claimants have the onus on themselves to take steps to protect themselves. In 134, the learned judge says, the defendants only sent a letter reserving their rights in relation to limitation in June 2021, well over a year after service of the claim form and the second defendant. Reserving their rights in relation to 17.22.
Is that not a relevant factor? I mean, if you had written right at the beginning, then the claimants would have had a chance to issue new claim forms and really all this would be academic, or might be academic.
Indeed. And my lord, the focus there is on should we have given the claimants a warning, were the claimants prejudiced by the lack of a warning that we were going to take this limitation point in relation to the amendments, that we were going to raise limitation. And the short answer to that is, it was blindingly obvious to the claimants from the very beginning, even before they issued the original case, that limitation would be a central issue in this case. That limitation points would definitely be taken by the defendants, just as they had already taken limitation points in Brazil through the company Suco Citrico. And just to complete the judgment before I turn to that, paragraph 136, the learned judge says she knows there's no requirement on the defendants to warn the claimants that there will be a limitation point taken through the 17.22 application. But the prejudice arises to the claimants as a result of the fact that the application and reservation of rights was not made earlier, and the reservation of rights was only in general terms. It was open to the claimants to have lodged a fresh claim form when it amended the claims in order to stop the limitation clock. But it was not apparent that a challenge on the basis of limitation would be made, and bearing in mind the number of claimants, difficult to see that the expense of such a step was necessary or proportionate. Just pausing there, that last point is unfortunately a further error. If it's suggested that a separate fee had to be paid for each and every claimant, that's not correct. The fee is for the claim form, not for the claimants. The claimants are listed compendiously on these claim forms. There are two claim forms.
And I'm afraid I'm not up to date on this. If a new claim form had been issued with all the relevant claimants, what might the fee have been?
I don't know the answer to that. I'll be told. But it would be for all of them together collectively.
Yes.
And the claimant's case is funded. They have they have funding to bring this action.
Just so that I check that I've understood it. Now, I'm not being part, I'm just trying to check I've understood it. These are amendments that were made without the need for permission for the court because they were made before service.
Yes.
So they would have had to have been an application to disallow first, and that should have been brought within 14 days. But you're saying it's still obvious that not just that limitation would be taken at some stage, but if amendments are made, applications to disallow may be made, and they may not be made until after the jurisdiction. So even if they haven't been told any of that, you're saying it should have been obvious to them that they knew all three of those things would happen.
Yes, Maria. And precisely because of how obvious it was that limitation would be taken fully. Both sides are well advised. They have expert solicitors and barristers, and have had them at all material times. No question of a lack of representation or an inequality of arms in this case. And the concern of the judge appears to be that the claimants were not warned or could not reasonably be aware that a limitation point would be taken in relation to the amendments. And our short point is that it was obvious that a limitation point would be taken, and they did not need to be specifically warned about it. They were in fact warned, but they would have been aware anyway. And the
Just before you go on the court fee point, I see on the existing claim forms there's reference on each claim form to a court fee of £10,000.
yes, I'll be told that's yes, we're told that's correct. But for claims of this magnitude, where very significant sums are being sought, the claim is funded. Really, the court should have no concern about that being a difficulty. But the point about it being obvious that limitation was being taken and taken fully was well known to the claimants, and it was recorded in the judgment of Mr. Justice Henshaw in the jurisdiction case. And could I ask you to look at that? This is the very final judgment. It's not in your bundle, but I will have it. I promise this is the last one from me. And don't be alarmed by its size. I'll take you only to a brief part of it.
Oh, I'm so sorry.
I'll ask you to go please to page, in the report, page 920.
My vision where
At the very top right-hand
yeah,
corner.
I see the note.
That's another one of Sedley's laws
Yeah,
and
right.
documents, that the pagination, there's only 3 different numbers for pagination on every page. But page 920, top left-hand corner, we see Mr. Henshaw referring to proceedings in Brazil. 164, he says, since January 2007, claims by citrus growers allegedly harmed by Suco Citrico, the defendant's company, have been ongoing. And then he refers to claims Favero at 165 and 166. And I note simply that the Favero claim was brought on the 23rd of January 2007. And halfway down that paragraph 165, the learned judge notes the claimants in the Favero claim include 3 who are also claimants in the Sanches claim, that is the claim before the English courts. That was in 2007. And if you go to 173, page 173, sorry, the paragraph 173 on page 924 is a reference to the Costa claim. Again, the claim in Brazil was issued in January 2007. And the defendants to the Brazilian, sorry, the defendants are undertakings alleged by the claimants to have participated in the same cartel, alleged cartel. 21 claimants in the Costa claim are also claimants in the Sanches claim. Now, no limitation point was taken in Brazil against these claims because they were issued in 2007. But if you issue a claim relating to the same cartel 12 years later in England, the reasonable litigant or advisor should appreciate that limitation is likely to be an issue. And if you continue in this judgment, page 926, there's a reference to Teles claim at paragraph 177. There's a reference in November 2019, interesting date, 22nd November 2019. Mr. Teles filed a claim against Suco Citrico in Brazil. And if you go please to, you see paragraph 178, the particulars are exactly the same as in our English claim. But then over the page at 179, on the 14th of August 2020, the Brazilian court held that the Teles claim was time barred, applying the 3-year limitation period. And carrying on that page is a reference to the Netto claim, page 183. Mr. Netto filed a claim in Sao Paulo in 2019. Mr. Netto was at that time also a claimant in English action. He wasn't a claimant in English action. But the claim was of the same nature of the claim in the English action. And page 928, paragraph 186, on the 8th of August 2020, again the Brazilian court, the first instance, held that the Netto claim was time barred under Brazilian law, applying that 3-year limitation period. And on page, paragraph 188, same page, the Giotto claim, Ms. Giotto sued Suco Citrico in Brazil. Same case as we see in the current action. And over the page 929, in July 2020, the Brazilian court struck out the Giotto claim on the basis of Brazilian law limitation. So we say it's unreal to suggest that the claimants were unaware that the defendants would not take limitation points against the claimants, that they would not take the same limitation points that their own company, Suco Citrico, had taken in Brazil under the same applicable Brazilian limitation law. And to my Lord Justice Lewis's point, can we assume they would have understood that the point would be taken as in opposition to the amendments? In our submission again, one must assume that would have been obvious to the advisors, since limitation has been taken consistently and rigorously in Brazil against, in some cases, these very same claimants. In any event, the defendants did notify the claimants of their intention to strike out the claims on the 7th of June 2021, and we reserved our rights, and that reservation of rights was recorded in the judgment of Justice Henshaw, in his judgment and in his order. And if you look back, go back to his judgment, you'll see it in paragraph 230. That's on page 944. Paragraph 230 at the second hole punch. 109 claimants were reportedly added to the Viegas claim by amendment under 17.1 in January 2020. And he records our submission that we're going to reserve our rights to apply to strike them out in the event that our jurisdiction application is unsuccessful. And in his own order, the order of the learned judge, he recorded our reservation of rights at recital 8. And that was in November 2021. The reference for his order, I shan't take you to it, is the supplemental bundle, tab 4, page 16.
I mean, for what it's worth, we're not given the hearing date, but presumably this isn't just November 2021, it must be earlier in 2021.
Oh, absolutely, yes. And the point here, in terms of whether an earlier warning to the claimants would have made a difference, the claimants only issued their protective claim on the 18th of November 2022. We get that from, let's double check that my reference is correct. it's recorded in our judgment, the judgment of Judge Dame Clare Moulder at paragraph 7, that the Cutrale claim, the protective claim, was issued on the 18th of November 2022. So the claimant's conduct doesn't suggest that they would have issued any protective proceedings any sooner. And this wasn't a case, wrapping up my submissions on why an extension ought to be granted under the overriding objective. It's not a case where our breach, if it was one, has prevented the court or anyone else from conducting the litigation efficiently and at proportionate costs. We were entitled to bring the challenge, the jurisdiction challenge. And it's not a case where rules were overlooked or ignored. We had in mind and reserved our rights in relation to Rule 17.22. We believed it was appropriate to wait until the jurisdiction challenge had been addressed. And the final consideration, no hearing or trial listing, was disturbed by our conduct. And so for all these reasons, we respectfully request that the extension of time be granted to allow us to make the points that advanced under ground 1 of our
No, I don't detect any further questions, so thank you very much, Mr. Kennedy. Mr. Cutrale.
Lords, I propose, if I may, to address the two grounds in the order in which they've been addressed by Mr. Kennedy. Although, on one view at least, it might be said that ground 2 is the logically prior ground, but nothing turns on that for present purposes. But it is agreed, as you know, and it's obvious, that the defendants have to succeed on both grounds in order to succeed on the appeal. Just by way of preliminary observation, in response to, I believe, a point that Lord Justice Nugee raised at the outset, which is that effectively there's been an assumption, one might say, in the arguments, that the court's approach to the exercise of its power to disallow under CPR 17.2 ought to be approached on the same basis as the power to amend or to refuse to amend more generally. That is not a point in issue between us for the simple reason that I believe there is in fact authority, not in the bundles, that show that the court does approach the matter in this way. That does not, however, mean that none of the factors or features of a disallowance situation might not bear on the analysis. And a simple example that, again, Lord Justice Nugee gave is in relation to the question of date of the amendment in the context of an application to amend, as established in WDA. The effective date of the amendment is taken to be the date when the court decides to give permission, or not as the case may be, rather than the date of the application. But nothing turns on that in our case, and whatever theoretical differences, therefore, might be justifiable on particular facts, as between those two regimes, I don't think that anything turns on that in our case. So let me therefore turn to ground 1 itself, and the statutory starting point in relation to this ground, which is contained in section 35. If we just have that briefly in front of us, and that is in the authorities bundle, volume 1, tab 3, page 7. The two key provisions in my submission are obviously subsections 1 and 3. Subsection 2 simply provides a description of what a new claim is, and nothing turns on that in our case. We all agree that that definition is engaged. It is the interrelationship between subsections 1 and 3 that is an issue. And what I say is clear from those two sections is essentially 5 points. First, subsection 1b, and I ignore 1a for present purposes because 1a is dealing with third-party proceedings. Subsection 1b, which I will simply shorten to subsection 1 for present purposes, is the foundation for the principle of relation back, i.e. the deeming of the commencement of a new claim added by way of amendment to be the date of commencement of the original action. And incidentally, all of the 5 points I'm going to make should be uncontroversial. But I think they are very important to appreciate right at the outset of the discussion in relation to ground one before one goes to the case law. The second point is this, that the prohibition in subsection 3 against allowing a new claim to be introduced by way of amendment to existing proceedings is manifestly intended to qualify or limit the operation of the relation back principle under subsection 1 in the circumstances described in subsection 3. And so it's tolerably clear, we say, that the purpose of subsection 3 is to protect the defendant against the introduction of a new claim, which, as a result of relation back under subsection 1, would lead to the defendant being deprived of the benefit of a limitation defense. Subsection 3 seeks to curtail the prejudicial effect of relation back where an applicable limitation period has expired. And that point is, in my respect, obvious. It flows logically and indisputably from the scheme of subsections 1 and 3. And that point is, in fact, admitted at paragraph 19.3 of the defendant's skeleton. I don't need to take you to it. I don't think it's controversial. The third point I make is this. The opening words of subsection 3 admit of the possibility of the disapplication of the prohibition against amendment, namely as provided by section 33 of this act or by rules of court. And of course it's common ground that section 33, which deals with personal injuries or death claims, is not relevant in this case, nor are the exceptions contained in the rules of court, in particular CPR 17.4 and 19.6, which positively permit amendments after the expiry of the limitation period. The fourth point, which should also be uncontroversial, is that on the plain terms of subsection 3, the prohibition against amendment only applies, quote, after the expiry of any time limit under this act. In other words, where it is not an issue between the parties, and it is therefore known and established that the applicable limitation period has expired when the new claim is sought to be introduced in the proceedings. Fifthly, subsection 3 does not deal with the situation where at the time when the amendment is made or proposed, there is a dispute between the parties as to whether the applicable limitation period has expired, and no determination has yet been made by the court of this question. What the subsection does not say is there is a prohibition against amendment after the arguable expiry of a limitation period. It refers simply to expiry of any time limit under this act as an established fact. This point is obvious, and in a sense is the explanation for how the case law has developed. And this point was not lost on the judge, because she rightly pointed out at paragraph 36 of her judgment, core bundle tab 15, after setting out the relevant sections, she says at paragraph 36 of her judgment, page 213 of the bundle, and I don't think that any criticism is made by the defendants of that particular observation. She says at paragraph 36, since section 35(3) applies only where a limitation period has expired, the case law has set out the approach of the courts when faced with an application to amend, at which point no determination will have been made as to whether the limitation period has expired. The crux of the appeal, therefore, as the court knows, is about the correct identification of the approach that has been taken in the case law. What, in fact, the defendants rather conveniently refer to, and usefully refer to, as the judicial solution that has been developed to proposed amendments introducing new claims when there is a dispute between the parties at the interlocutory stage as to whether the relevant limitation period has expired. And as you know, the gist of the disagreement between us is that the defendants contend, on the one hand, that the judicial solution that has been developed has been to focus solely on the question whether there is, at the time of the proposed amendment, an arguable limitation defense on the part of the defendant, or whether, as we contend, the judicial solution has been to consider, depending upon the facts of the case, both the element that the defendants have identified and whether this arguable limitation defense of the defendant will be prejudiced by the operation of the relation back principle. So with that in mind, and before I turn to the case law itself, I just want to make one brief observation in relation to a point made at paragraph 33 of the defendant's skeleton, which has also been, I think, reiterated in oral opening, but perhaps with less vigor than how it's presented in the skeleton. If you look at paragraph 33, and this is page 124 of the core bundle, although I suspect you may well have that document as a separate document by now. They say, and this is their first attack on the judge's judgment, they say the language of section 35(3) of the 1980 Act does not impose any additional requirement that the defendants must be prejudiced by the operation of the relation back principle. In other words, they're saying all that section 35(3) refers to is expiry of the time limit, and it contains the absolute prohibition against amendment. And we say that this argument overlooks the points that I've just made, that subsection 3 lays down a prohibition against amendment where it is established that the applicable limitation period has expired. It doesn't address the situation where there is a dispute as to, and it is therefore unclear and unknown whether the limitation period has expired. And where there is such a dispute, as we say the case law demonstrates, the way in which the courts have approached the issue is by reference to the court's exercise of discretion, having regard to the general purpose and intent underlying subsections 1 and 3, rather than by means of direct application of the strict letter of subsection 3. And that is why, when you look at the cases, in fact, none of them directly concern themselves with the precise linguistic meaning, if I can put it that way, of subsection 3, and whether or not the facts of the particular case fall within that. Because that is not, those are not cases where it is established or not in dispute that limitation has expired. So that therefore means we have to turn to the case law. And perhaps I can start, and I appreciate you've looked at the case law already, or certainly most of it, and I don't therefore have to dwell too long on it. But if I can ask you please first to start with WDA, which is in the authorities bundle, tab 17, page 574.
Before we look at that, I know that you're going to tell us that this is what the case law has done, but it's not obvious that we had to do it this way. Logically, you could have said, because of the prohibition in section 35(3), if there's any question of a possible limitation defence, you have to resolve that before deciding whether to grant permission.
Yes. Well, that possibility, of course, is alluded to in Chandra, where
yes,
the possibility of ordering a trial of a
preliminary issue. I mean, it's often very inconvenient to do it.
Well, yes, and that usually, you're absolutely right. That would be a potential judicial solution. And I apologize if I've described the judicial solution in terms that are perhaps too stricter than the case law actually identifies. You're absolutely right. There are, in fact, two other solutions, if I can put it that way, that have been developed in the case law to deal with this problem. One additional solution is to not simply look at the question of whether to amend or to refuse, or to amend, to give permission to amend unconditionally, if I can put it that way, or to refuse amendment. That's one possibility. The second is to order a trial of the preliminary issue on limitation. The third, which has been adopted in some cases, has been to allow amendments, but on the specific term that the amendments are to be taken to take effect only from the date of the amendment. MasterCard, exactly, and it's
there is in fact a further variant on MasterCard, which I adopted once, which is you can allow the amendment and leave it to a trial judge to decide. It particularly applies whether it's the same or similar facts.
Yes.
Leave it to a trial judge to decide if a new cause of action relies on the same or similar facts. If it does, then it can date back. If it doesn't, then it takes effect from the date of the amendment.
Yes. I quite accept that is a possibility too, and I think that possibly has been adopted particularly in the cases where the application of CPR 17.42 has been disputed, the question of similarity of facts.
Yes, which is not our case.
Which is not our case.
Yes.
But in our type of situation, the usual solution has not been to order a preliminary issue of a trial, but to deal with the application as it stands on the basis of the parties' formulated cases on limitation and on the basis of such evidence as is available, and to decide there and then whether to exercise the discretion or not, or to exercise it, to refuse or to allow the amendment. Now, one argument that we did advance to the judge was if she were in doubt on the question of prejudice, notwithstanding, we say, the very binary nature in which the parties' limitation cases are set up, we said to her, well, if you had the slightest doubt about that, you could give permission, you could dismiss the application to disallow, but only on terms that the amendments should be treated as taking effect, respectively on the dates when the amendments were made, i.e. on the 22nd of November 2019 and the 23rd of January 2020.
Effectively the MasterCard solution.
Effectively the MasterCard approach. We said to her, on the basis that they say it's unfair, as it were, that they lose the benefit of this very theoretical possibility of limitation having expired effectively between 27th of September 2016 and either the 22nd of November 2016 or the 23rd of January 2017. A case which, in my respectful submission, is pretty far-fetched on our facts, but I'll come back to that later. But if she had concerns about that, she could address that prejudice effectively in that way. But of course, you will have noticed that there was no enthusiasm, understandably, from the defendant's perspective for that solution, because what they want is to reap the benefit of the fact that, as it happens on the facts, the claimants did not issue a protective claim form until much later in November 2022, which is way later than even the 6th of March 2021 date, which is the claimant's own case on limitation expiry, unless a protesto has been filed, which would then restart the interruption of time. So, of course, I mean...
So there is a real prize for them in this.
Absolutely, yes. And of course, that of itself doesn't mean that their position is wrong, but I simply make the point that insofar as the complaint is of prejudice, there is, if it's a realistic complaint, and I will come on to the question in a sense which is interestingly not explored in the authorities, but which, in my respectful submission, Lord Justice Newey has at least raised the question about, which is the standard by which you address the question of prejudice by reason of relation back. Usually, it should be self-evident, and one should not have to worry about what standard of proof, as it were, or persuasion should be an issue at the interlocutory context from the court's perspective. But if when I come to it, I will be making the point that it can't be sufficient for a defendant simply to say, well, the moment limitation has been raised, essentially anything is possible, and therefore prejudice, as it were, should be assumed and should be treated as axiomatic, which is effectively the more extreme of my learned friend's positions, but it's obviously his primary position. But when it comes to his secondary position, which is, well, if you look at the facts closely enough and you can see some prejudice, my submission will be that there needs to be a reasonably arguable case of prejudice by reference to a realistic possibility of some alternative limitation defense that would be prejudiced by the operation of relation back. It can't be enough simply to say, we never know what might happen at trial, because one can always say that, and by mere dint of that, prejudice should be assumed. But I'm getting ahead of myself, perhaps in relation to that point. But just in answer to your lordship's point, I quite accept that there may be a number of solutions potentially.
Are we going to? We're obviously going to ask us to dismiss the appeal, but if we thought there was something in the appeal, are we being asked to consider these alternative solutions, MasterCard type solutions, as a fallback, or is that not part of your case?
Well, for my part,
You'd be quite happy.
I would be content.
But might you not need a respondent's notice on that point?
Well, it's a point. I would respectfully suggest it's a point that that is open to me. It's a point that we made to the judge at first instance. It's a point that we've identified in our skeleton argument as a possibility, and it's a point that I mean, in circumstances where my learned friend himself is invoking the court's original jurisdiction in relation to an extension of time, I would respectfully suggest, in order to be able to pursue the disallowance point, if one were to be in that territory of effectively an exercise of discretion afresh, having granted an extension of time, then in my respectful submission, that course would be well open to you. And that would remove that element of prejudice if it were real. So, my lords, coming back to my treatment of the case law, I was going to take you first to WDA. And I think that we can, particular facts don't matter, but just for context, I don't think I need to take you through the detail of the head note, but so you have it by way of scene setting. That was a claim for negligence against engineers in respect to the design of various factory units. The original claim related to 2 units, and the WDA's claimant subsequently sought to introduce new claims of negligence in respect of 10 other units, as well as a new claim of negligent misstatement. The official referee allowed the amendments in respect of the 10 other units on the basis that those new claims arose out of similar facts. But he refused to give leave to add the new claim of negligent misstatement, whilst holding that in the light of the provisions of Section 14A of the Limitation Act, it was unclear whether, in other words, it was reasonably arguable that the claims for negligent misstatement were barred by limitation. And there was an appeal against that decision to the Court of Appeal. And the relevant part of the Court of Appeal's judgment is that which deals with the proposed introduction of the negligent misstatement claim, which effectively begins at 577 of the bundle. In fact, if I use the if I take you to the key passage on page 583, you will see under the heading, the agency's appeal against the refusal to allow amendment to claim for negligent misstatement begins on next to letter E. And what the Court of Appeal does is to summarize what the judge decided. If I could please ask you to read the passage next to letter C over to page 1420 to the end of letter G. It's quite a long passage.
So, sorry, it's C on 1419.
So it's, yes, 584 letter C
Yep.
to 585 letter G.
Yeah. Yes.
Thank you. And so you will note that the court was obviously aware of the terms of section 35.3. Those were actually set out at 584 letter F. And in fact, Lord Justice Gladwell himself had set those provisions out on page 580, letter D, where he quotes from section 35 itself. So it's not as if, therefore, the absolute nature of the prohibition in section 35.3 was unknown to the court. But the issue that confronted the court, as appears on page 584, letter H, is that limitation, the issue of expiry of limitation was disputed. The question was whether there was an arguable case one way or the other. At the top of page 585, subparagraph 8, Roman 8, is important because the quintessential case that is being addressed by the judge and by reference to which he describes the approach of the court, it is described in these terms. The approach of the court should differ according to the nature and effect of the proposed amendments. If the amendment adds a new claim, and the relevant limitation period expired between the date of the writ and the date of the amendment, section 35.1 will, after amendment, deprive the defendant of a limitation defense he would otherwise have had. That's the, as it were, the model of prejudice, the intrinsic prejudice scenario that is being considered as a result of the unconstrained operation of section 35.1. The question, therefore, of deprivation of a limitation defense or of an advantage, unfair advantage, as it were, being conferred on the plaintiff, has to be understood from that perspective. And so when you see, for example, references in points Roman 10 to any injustice, the second sentence, any injustice to the defendants by depriving them of a limitation defense they would otherwise have would thus be avoided, as well as the reference further on in paragraph Roman 11 in the final sentence, thus amendment to allow the addition of this claim would give the plaintiffs what might be the unfair advantage of relation back under section 35(1). Those observations in my respectful submission have to be understood in the light of the axiomatic scenario, as it were, that's been considered in paragraph Roman 8 earlier. So that was what the judge had found and how he'd approached it. And the Court of Appeal then deals with it at the beginning of, on page 588, letter H. We now turn to consider the second argument advanced by Mr. Keating in support of the agency's appeal. This is that Judge Hicks was wrong in the approach which he adopted, as summarized in paragraph 7 above. That, I believe, is a mistake. That is a reference, an intended reference to paragraph 8 above. Namely, that if it is reasonably arguable that the relevant limitation period has expired before an amendment is made, so that section 35(1) may deprive the defendant of a limitation defense he would otherwise have, the onus is on the plaintiff to show that the amendment comes within the provisions of section 35(5) and order 20 rule 5(5). In other words, the exceptions pursuant to rules of court. In making this submission, Mr. Keating relies upon a passage in the judgment of Lord Justice Glidewell, with which Lord Justice Fox agreed in Leicester Wholesale Fruit Market. And there's a reference there to that description of the facts of that case. If I can ask you, please, to read the short summary of facts
Between A and C.
Between B and C, thank you, yes. So, in other words, on the facts of that case, interestingly, it was a pre-service amendment case where, I mean, if authority were needed, as it were, for the proposition that one approaches the disallowance jurisdiction in the same way as the permission to amend jurisdiction, the decision in Leicester Wholesale is indicative of similarity of approach. Lord Justice Glidewell then goes on in WDA. That Lord Justice was clearly the relevant Lord Justice in both of those cases, but in the WDA case, it goes on to say, next to letter C, in his judgment, after quoting the relevant parts of section 35, Lord Justice Glidewell said at page 111, it follows therefore that if at the time when a further defendant is added to an action by amendment, he has a limitation defense, which he could raise if the plaintiff then issued a new writ against him. But if that defense would not have been available to the defendant at the time when the writ was originally issued, he should not be joined as a defendant, because he would thus be deprived of a defense which he would not have been, which would not then have been available to him. And the words, if that defense would not have been available to the defendant at the time when the writ was originally issued, are important in this context, because what those words show is, just as the description of the basic scenario in paragraph Roman 8 that we saw earlier indicate, is in that passage, the judge is dealing with the situation where limitation expires between the date of commencement of the action and the date of the amendment. And in that situation, it is being said, or was being said by Lord Justice Glidewell in Leicester Wholesale, amendment to amend should not be given. But, and this is the critical but, he goes on to contrast that situation with the facts before him. He says, he then went on to say, however, that there was no evidence in that case, that's in Leicester Wholesale, that if the claim was statute barred when the writ was amended to add the additional defendants, it was not so barred when the writ was originally issued. In other words, the issue between the parties was whether the cause of action had arisen over 6 years before the date when the writ was originally issued, or on a date much more recent, or on a much more recent date, as the statement of claim alleged. That is to say, some 3 years before the issue of the writ. Lord Justice Glidewell continued, of course, if the second is correct, there is no question of limitation. If the first is correct, there would have been a limitation defence if Hallam's had been a party from the start. He did not say this in terms, but it is thus apparent that in that case, or I would suggest, by extension of reasoning, in that type of case, Section 35(1) gave no advantage to the plaintiffs. And what then happens if you are dealing with that kind of case? You then find yourself in the situation where the defendant can only object to the amendment if the limitation defense is essentially indisputably good. In other words, the action is itself abusive because there is an obvious and indisputable limitation defense to it. And this is what the passage that's then quoted in letters G to H identified. In other words, in that kind of situation, the plaintiff, the defendant is then would then have to prove that essentially the plaintiff has got no conceivable defense to that limitation defense.
But for what it's worth, I mean, you see here, and Mr. Kennelly referred to this, you get references to abuse of process. But my recollection is that pre-CPR, if you had a good limitation defence, you had to say abuse of process because limitation didn't wipe out the cause of action. It only prevented it being pursued. And therefore, you couldn't say there was no cause of action. You had to say abuse of process, is my recollection.
Yes, but I think that in what is being referred
it's not contrary to what you're saying.
No. I think your Lordship's point simply means that obviously the term abusive process can be used in different ways.
Yes.
But in the context in which it's being used here, it's being used in the sense of the plaintiff then has to forgive me, the defendant in a case where his limitation defense would not be prejudiced by operation of relation back. If he wants nevertheless to oppose the amendment, then he can only realistically do so by demonstrating that his limitation defense is effectively unanswerable and that the attempt to answer it is not realistic, which obviously then is tantamount to saying the action is being pursued on frivolous or vexatious or abusive grounds. So that's a scenario, therefore, that Leicester was addressing. And one of the questions that Lord Justice Glidewell then goes on to address is, well, where that is not the case, what is the test? Which is what you then find on page 145, which my learned friend has already taken you to. But what you also note on page 125 is even when the court is expressing or is focusing on what they say is the only element, namely what I'll call the arguability of limitation element. Even when the court is focusing on that element, repeatedly, that element is described in terms that refer to an reasonably arguable limitation defense which will be prejudiced by the operation of relation back. You see that, for example, in the quotation on page 590, letter D, from Grimsby, from Lord Justice Purchase's judgment, where he says, leave to add a new party should not be given unless it can be shown that the defendant did not have a reasonably arguable case on limitation, which would be prejudiced by the additional claim, by the additional new claim. In other words, which would be prejudiced as a result of the relation back of the new additional claim to the date of commencement of the original action. And then further down, next to letter G, or just above it, we now wish to make clear that though the test applied in Leicester Wholesale was the correct test in the circumstances of that case, in which section 35(1) gave the plaintiff no advantage, it was unnecessary for the decision in that case to disagree with what Lord Justice Purchase had said in Grimsby. But if you focus on the first part of that, it's again reinforcing the point that obviously if one can say on the particular facts of a case that relation back will grant the plaintiff no advantage, which is the same thing as saying that the defendant's limitation defense will not be prejudiced by relation back, then there would be no basis for refusing to allow the amendment. And one can see that that point being further reinforced between letter G and letter H. So that's WDA, and we say that you effectively get 3 key points out of that case law, admittedly established under the RSC at this stage. The first is the critical consideration is whether allowing the amendment will, as a result of the operation of relation back, deprive the defendant of its limitation defense and thereby confer an unfair advantage upon the claimant. Second, where allowing the amendment would have that result, as long as the defendant's limitation defense is reasonably arguable, then the amendment will not be allowed unless one of the specified exceptions applies. But where the nature of the defendant's limitation defense is such that, if established, that defense would be as effective a defense to the original claims as to the new claims, then there is no justification for refusing the amendment, unless the defendant can show that its limitation defense is so clearly made out, even at the interlocutory stage, that the pursuit of the whole action is abusive. Then Chandra, which is tab 27, volume 2 of the authority fund. Same bundle, in fact, tab 27. You will see that again, the 3 Lord Justices, with the leading judgment being given by Lord Justice Jackson, were obviously well aware of the terms of section 35. You see that in paragraph 8, where section 35 is set out, including at the top of page 763, the provisions of subsection 3 are set out. And then at paragraph 9, the judge says, I shall refer to the deeming process prescribed by section 35(1) as relation back. At paragraph 50, you will see that Lord Justice Jackson describes how behind the procedural wranglings between the parties, there lay a formidable point of substance. This was the question whether the amendment raised new claims which were precluded by section 35(3). And then he goes on to describe from paragraph 56 what the judge had decided. I don't think the facts particularly matter for present purposes. My learned friend agrees that in that case there was no general limitation defence of the kind that existed in Leicester Wholesale. What is interesting in that case is that the judge had in fact proceeded to treat the application to amend before him rather as if it were a trial of a preliminary issue. having started his judgment saying, I am not dealing with a trial of a preliminary issue, he effectively then delivered a judgment which could only have made sense if he were dealing with a trial, going on to make, as it were, final findings on limitation. And you see that in paragraph 58, where the notice of appeal criticizes what the judge did by wrongly treating sub 2 and sub 3, wrongly treating the hearing as the trial of a preliminary issue on limitation rather than an application to make or set aside amendments to pleadings. Applying the correct approach, the judge ought to have held that the claimant's amendments arguably raised new causes of action outside the limitation period, therefore those amendments could not be allowed. So you can see there that what was an issue in that case was not the prejudice element, if I can put it that way, that might arise by reason of relation back. The question that was an issue on the facts of Chandra was the arguability of the limitation defense element of the analysis. And that is the point made by the judge in her judgment when the other side rely on particular passages in Chandra as not referring to the prejudice issue. If we pick up the substance of the Court of Appeals judgment, we can start with paragraph 63, where Lord Justice Jackson says the starting point for consideration of this issue is the Court of Appeals decision in WDA, and then a reference to the facts. Paragraph 64, the Court of Appeal dismissed appeals by both parties and upheld the official referee's judgment. In particular, the Court of Appeal endorsed his approach to new claims which do not arise out of similar facts. The Court of Appeal held that where it was arguable that a new claim was statute barred, leave to amend should not be given. The plaintiff should not gain the benefit of relation back under section 35(1). On the other hand, if the plaintiff could show that the defendant did not have a reasonably arguable limitation defense, which would be prejudiced by the operation of section 35(1), then the court may give leave to amend. See the judgment of the court at page 1425, letters G to H, which I've already shown you. So that passage is a clear endorsement, in my respectful submission, of the approach of the court in WDA, which itself had endorsed the approach in Leicester Wholesale, at least in a case where there was a general limitation defense. That endorsement, in my respectful submission, highlights again the importance of the question whether the claimant would be unfairly advantaged and the defendant prejudiced by the operation of relation back in relation to the limitation defense. And then paragraph 65, WDA was a case which proceeded under the old RSC. Nevertheless, the provisions of the former RSC are for present purposes substantially the same as CPR Rule 17.4. Both the old rules and the new rules are intended to implement Section 35. The guidance given by the Court of Appeal in WDA remains effective. And then you can see what is then added at paragraphs 66, 67, and 68. You will see that in paragraph 68 in particular, there is a reference there again to the limitation issue will then be determined at trial and the defendant will not be prejudiced by the operation of relation back under section 35(1). So again, reassertion of that concept being at the heart of how the discretion is to be exercised. And the passages, incidentally, I think in relation to split preliminary trial as a potential judicial solution for interest, you will see what Lord Justice Jackson says about that in paragraph 70, having identified the ways in which the court may deal with a dispute at an interlocutory stage, but as to whether or not limitation is expired. The passages of Chandra that I've highlighted were relied upon by Dame Moulder, paragraphs 39 to 42. of a judgment, and reinforce the key principle established in WDA, as summarized by the judge at paragraph 39. You may wish to cast a quick glance at that. So this is paragraph tab 15 of the core bundle, page 215, starting on page 215. So she, having set out the relevant passages from Chandra and its and the quotation, as well as the reference to WDA in Chandra, she then sets out her views and her analysis of those authorities in paragraphs 39 to 42. I don't need to go through the detail of that. In my respective submission, the analysis in paragraphs 39 to 42 is exactly on point and consistent with the case law. And we say that standing back from the judgments in WDA and Chandra, the key principle that emerges from those cases in which the judge applied is entirely consistent with the scheme of subsections 1 and 3. Because as I submitted earlier and the defendants accept, the purpose of the prohibition in subsection 3 is to preempt the prejudicial effect of relation back under subsection 1, where limitation has expired, and therefore for the courts to permit an amendment in circumstances where there is a dispute as to whether limitation has expired, but there would be no prejudicial effect by reason of relation back, because of the nature of the defendant's limitation defense. To permit amendment in such circumstances is entirely consistent with the overall scheme of subsections 1 and 3. And it's also consistent, in my respectful submission, with justice and common sense. It would be unfair to the claimant, pointless from a general case management perspective, and contrary to the overriding objective, to refuse an amendment and force the claimant to start new proceedings with all of the additional costs, delay, and duplication that would inevitably result from the multiplication of proceedings if relation back would not deprive the defendant of its claimed limitation defense. If I can deal with the other case law referred to by my learned friend in his oral submission briefly. First, Cameron Taylor. I think I can take that quite. Before the judge in the court below, the defendants had suggested that this court had in fact departed from WDA and Chandra in Cameron Taylor. And that is why you'll notice and see that in paragraph 46 of her judgment on page 216, she says, the issue is then whether the cases which the defendants relied on, which post-dated Chandra, have modified or amended the law in this respect. And there's a hint of a continuation of that argument as well in my learned friend's oral submissions, where when he referred to the modern formulations, as it were, not referring to the prejudice element. Now we say that for the reasons that the judge gave at paragraphs 46 to 54, which I don't need to take you to, but which I ask you to take note of, it's very clear from the relevant passages of Lord Justice Coulson's judgment in Cameron Taylor that there is no conflict between Cameron Taylor on the one hand and WDA and Chandra on the other. On the contrary, Cameron Taylor considers and follows WDA and Chandra. And I ask you to note 3 specific points. I think I can do that very quickly by reference to the judgment in Cameron Taylor. So this is tab 47 of the authority bundle, volume 4. If we go to paragraph 34 on page 1291, you'll see there that Justice Coulson treats the Court of Appeal's judgment in WDA to be the starting point in considering the interplay between limitation arguments and amendments, quoting, in fact, in paragraph 34, what he described as the important passage at page 1425, letters G to H of WDA, which you've already seen, which is the very passage containing the statement of Lord Justice Glidewell in WDA that Leicester Wholesale Fruit Market set out the correct test on the facts of that case, i.e. where there is a general limitation defence, where relation back under section 35(1) gave the plaintiff no advantage by reason of, and therefore did not deprive the defendant of its limitation defence. Then at paragraph 35, you will see that there again he quotes from and at least implicitly approves of the fact that the decision in Chandra established that the guidance in WDA remained as applicable under the CPR as it was under the old RSC. And at paragraph 38, he says more explicitly that he considers that the right approach is that explained in WDA and subsequently reiterated by Lord Justice Jackson in Chandra. Now, my learned friend made the point that on the facts of Chandra,
Chandra or Cameron Taylor, sorry.
I'm so sorry, on the facts of Cameron Taylor, forgive me, on the facts of Cameron Taylor, there was a general limitation defence. Now, 2 points in relation to that. First, it's very far from clear from the report that only a general limitation defence was pleaded and that there were not also alternative limitation defences that would be prejudiced by relation back. It's simply not clear at all from the report as far as I've been able to tell. Secondly, in any event, the argument that we're presently concerned with was clearly not raised by the claimant in that case, and was obviously not addressed. And therefore, if the suggestion is this court should treat Cameron Taylor by implication, as it were, as disapproving of what the Court of Appeal in WDA had said was the correct test on the facts of Leicester Wholesale. If that is a submission, it's not quite been put that way, but if that is a submission, then I respectfully say that this court should reject that. There's no basis for it. What you do know, because that is what Lord Justice Coulson says in terms, is that the guidance in WDA sets out the correct approach. And that, in my respectful submission, is the guidance not only in cases where the argument is that limitation expired between the date of commencement of the action and the date of the amendment, but also those cases, admittedly much rarer, I accept, perhaps rarer, where limitation is said to have expired in relation to all claims, original and new. I believe the defendants have also submitted that WDA and Chandra are not authority for the propositions that the judge extracted from them, because neither of these cases involved facts where a defendant advanced a general limitation defence. Now, the short answer to that is, as we've seen already, the Court of Appeal in WDA specifically considered the special factual situation in Leicester Wholesale and held that the Court of Appeal in that case had adopted the correct approach to that kind of scenario, which we say our case is very much like. But secondly, irrespective of the precise facts of WDA and Chandra, the principles that those decisions identify from the already existing case law, including Leicester Wholesale, we say are clear and authoritative. My lords, Ballinger was another case that was cited to you. That was the case which it is said also contained an argument of a defence of where a defence of a general limitation defence was advanced. But 2 points in relation to that. First, again, the question of lack of prejudice by reason of the operation of relation back was not raised and not addressed by the court. But more importantly, notwithstanding that point was not raised, insofar as the court addressed the critical consideration, it is clear from the judgment of Lord Justice Purchase at paragraph 20, forgive me, from the judgment of the court at paragraph 25. I don't know, you presumably have that as a separate document.
Yes.
If you look at paragraph 25, where the court describes the general problem that arises in this kind of case, it must be borne in mind that the context of the debate is the doctrine of relation back, introduced by section 35(1). If a new claim is permitted by way of amendment, it is treated as having been made by way of a separate action commenced on the same date as the original action. So where an amendment is permitted to introduce a new claim, which was in time at the date of commencement of the action, but arguably out of time on the date on which permission to amend is granted, the defendant is thereafter precluded from reliance at trial on the arguable limitation defense. So that the formulation of the critical situation that is being looked at, that created by section 35(1 and section 35(3) is being described in the same way that Judge Hicks had identified it in that summary of his judgment in paragraph Roman 8 in the judgment of Lord Justice Glidewell in WDA, which is the classic situation, in my respective solution, the critical situation that's being addressed. And so I rely on that as supporting the approach in Leicester Wholesale as approved in WDA. And in any event, insofar as the other parts of the judgment are concerned, if you look, for example, at paragraph 28, again you see the all-important references by the judge to whether or not the defendant's case will be prejudiced by reason of relation back. You see that in the first part of paragraph 28, where reference is made to a case where section 35(1) does or may well give the plaintiff an advantage, not being given, unless the plaintiff can show that the defendant does not have a reasonably arguable case on limitation which will be prejudiced by the new claim, i.e. by relation back. And even further on, where reference is made to what Lord Justice Millett said in Paragon Finance, he said that by this means, the injustice to the defendant of depriving him of an arguable limitation defense is avoided. So all of these, in my submission, point to the same idea. So far as Grimsby cold stores is concerned, I don't think that I need to take you to that. You have seen the judgment in that case. I make 2 points about that. Although a general limitation defense was advanced in that case, the argument of lack of prejudice by reason of relation back was not raised as such again, and was not considered by the court. But in any event, what is clear from the last page of the judgment, and that's the top paragraph and on the last page, the final sentence, is that prejudice to the defendant's limitation defense that result from relation back is the key consideration in relation to the question of the exercise of the court's discretion. So in that sense, in my respectful submission, it's entirely of one piece with the case law that we've seen so far. Very brief final observations before I turn to the question of alleged prejudice on the facts, which is the defendant's reliance on first instance decisions. Now that argument was broader in scope before Dame Moulder. It's reduced in size on the appeal, but I believe that reliance is still placed on at least Mr. Justice Mann's decision in G4S as evidencing the supposed approach of only focusing on the question of the arguability of the limitation defense, not on the question of whether relation back will prejudice the defendant by depriving him of a limitation defense. And we make three short points about that continued line of argument. First, the judge comprehensively dealt with the first instance authorities at paragraphs 55 to 66 of her judgment. And it's not really been demonstrated how her reasoning was wrong in any way. Secondly, as we have explained at paragraph 31 of our skeleton argument, the position in G4S is that the defendant had put forward alternative cases on limitation. I think a point that Lord Justice Nugee has already identified, one of which meant that limitation expired between the date of commencement of the original action and the date of the amendment. And so to that extent, therefore, if the point that we have raised in this case had been raised in that case, one can well see how Mr. Justice Mann would have dealt with it differently in the facts of that case. And thirdly, in any event, if the judge rightly identified the applicable principles from WDA and Chandra, it matters not, at least not before this court, that there may be a first instance authority that failed properly to apply those principles on the facts before it. I don't think that I need to deal with the invitation in the defendant's skeleton that this court should depart from WDA and Chandra. That point's not is not pursued orally, and I assume that I don't need to take you to the requirements of Young and Bristol Aeroplane. So that allows me, I think, then to turn to the question of alleged prejudice on the facts. Now, the judge explained in paragraph 43 of her judgment why the defendant's limitation defense would not be prejudiced by the relation back of the pre-service amendments. And I just want you, I want to take you back here to the defense, if I may, which is core boundary tab 26. One point, forgive me, just in relation to the points we make at paragraph 31 of our skeleton in relation to G4S, just for the record, one additional point I ask you to note is in addition to paragraph 19 of G4S, where it is clear that the judge was addressing a scenario where alternative limitation defenses was being deployed. Can I please ask you also to look at paragraph 16 of G4S, where he describes, again in very similar terms to what we see in Ballinger, paragraph 25, and paragraph Roman 8 of WDA, the situation that section 35.3 is addressing, which is where limitation expires between the date of commencement and the date of amendment. But defense, in particular where limitation, the defendant's limitation case is set out, which is page 463, there are alternative limitation defenses being set out by the defendant. The judge simply referred to the date of February 2009 as being the relevant defense, but that should not mask the fact that the defendants, obviously highly sophisticated operators and represented by able lawyers, have obviously given this question considerable thought. Moreover, and this is perhaps something that's not necessarily apparent to your lordships, at first instance there was detailed Brazilian law evidence before the judge in the form of 2 expert reports, or in fact more. I think there were 2 rounds of expert evidence from one Professor Coutinho from on behalf of the defendants, and I can't remember the name of our expert offhand, but there was Brazilian law evidence purporting to support the pleaded case. It wasn't a situation where may at times happen at an interlocutory stage where people simply articulate a general defense without any detail, without any evidence. Because one of the possibilities initially was there was an assumption that there could possibly be an argument about what was or wasn't arguable on limitations. So both sides therefore came suitably armed with detailed expert evidence. And the evidence of the defendant's expert, which is reflected in their pleading, is essentially a twin approach to limitation, which is to say, one, there is expiry of limitation by reference to the date of violation of the rights, which is what you find in paragraph 75. That the primary limitation period is 3 years from the date of the alleged violation, or in exceptional circumstances from the date on which the injured party became aware of the alleged violation. And if you translate that to the facts of this case, i.e. to the practice, the business of orange farming, what it basically means, they say in paragraph 76, is that the date of the alleged violation was no later than the date on which the relevant orange purchase contracts were executed, which is their primary case. And obviously, if that case is correct, the limitation expiry is way earlier than February 2009. It may even be before some of the later part of the alleged infringement period of 2006, in the case of some of the earlier contracts. But alternatively, they say, insofar as knowledge is relevant, their case is the date on which the claimants had the relevant knowledge was no later than February 2006. And they then go on to say, any cause of action accruing prior to February 2009 is therefore time-barred. And importantly, they have given full consideration to the question whether, for example, there might be an alternative defense of limitation based on the publication of the TCCs in late November 2016, a point that's been given greater prominence on this appeal in the light of my learned friend's oral submissions. But again, just to set the scene in terms of what the material is on, well, what are the parties saying about limitation? I want you to bear that in mind. And the point is this, that in relation to the question of issue of the publication of the TCCs, at tab 22, forgive me, I think I've given you the wrong reference. Tab 16 of the supplementary bundle. So that's the first volume of the supplementary bundle. This is the expert reporter, Diego Coutinho, who is a professor of law in Sao Paulo University, and he gave evidence on behalf of the defendants at first instance in writing.
I'm not quite sure how this evidence ties into the question of prejudice at the moment. What do I get when I look at this?
So the point the general point I will be making in relation to prejudice is that the court approaches, rightly in my submission, approaches the question of prejudice and whether there will be prejudice by reason of relation back, by reference to the defense that the defendant has articulated. That is primarily what the court is focused on. I entirely accept that the court should not be blind to what the claimant might respond in relation to that defense, and that obviously there could be cases where in the light of both parties' pleaded cases, there might be some obvious possibilities for alternative limitation expiries. I accept that. The point I am on at the moment is I want to make very clear to the court what the defendant's case is and what it is based on. And in particular, what I want to make clear is that the defendants have clearly considered, as part of their defense, the question of the relevance of the publication of the TCCs in late November 2016. And their case on that, you will see on page 202, is summarized in the 3rd paragraph. I'll come back to that in a bit more detail later, but I just want you to note the evidence that they adduced. They say that second, in the Teles and Giotto claims, the TJSP, so that's the relevant Brazilian court, rejected the submission that the 3-year limitation period started to run as at the date of the TCCs in 2016. So those are the November, late November 2016 TCCs. So that was their case and their evidence, which is of course why they have never pleaded an alternative, a third alternative limitation defense in their defense. They have obviously given careful consideration to that point, and in the almost 2 years in which their defense has been on the record, they have never sought to expand on it by adding a third alternative limitation defense.
What is paragraph 78 about?
Paragraph 78 is a slightly different point. Yeah,
Third defense.
no, it's not a defense. It's a response to what's called, in relation to the runoff period. I think the way in which the case is set out in the MPOP is that we say that the principal period during which the alleged cartel activity took place, which forms the basis of the claims, is the period January 1999 to, I think, January 2006. But what we say is that the damage that activity caused didn't stop at January 2006, but would have continued sometime thereafter. It's fair to say the precise definition in terms of the length of the runoff period is not being pleaded, but obviously, as one can imagine, there will be a limit to the runoff period. I don't think anybody has suggested that the runoff period relating to, and certainly we've not pleaded that the runoff period in relation to the cartel activity between up to 2006 runs all the way through to 2016, for example. The amended case that we've advanced is that in fact the infringement period itself was much longer. But I'll come on to the relevance of that, if any, to the appeal in due course. So I just wanted to show you what the case was, as it were, that the defendants advanced before the judge. And so the limitation defences that have been pleaded in paragraph 76 and 77 are both breach-based and knowledge-based limitation defences, all of which are said to have expired at the latest February 2009, but obviously in accordance with the principles relied upon, would in many cases have expired long before that. At no stage have the defendants alleged or let alone pleaded a positive case of their own that they have a defense of limitation expiry as of 29th of November 2016, when the TCCs, for example, the existence, not the content, the existence of the TCCs was published.
Can I just talk round it for a moment?
Yes.
You obviously respond, well, let me start differently. It's common ground, is it, that in principle there could be two relevant starting dates, so to speak, the date of breach or damage, I don't know which, on the one hand, or the date of actual or constructive knowledge.
Well, let's call it relevant knowledge for present purposes.
Right.
So
Relevant
I want to import
knowledge.
English law principles.
So and the first will be a long while ago, so we're concerned with the date of relevant knowledge.
Yes.
and the defendants say data relevant knowledge, long time ago, statute barred. And you say, no, that's wrong. Time didn't start to run until, at the earliest, the 6th of March 2018.
Yes.
Now, suppose the judge thought the time started to run, that there was relevant knowledge earlier than that, but still on a date that allowed some of the claim to proceed. Would you say the judge could not make a finding to that effect and would have to go with either the defendant's case or your case, even though the judge actually thought the position was in the middle?
No, I don't say that. Of course, I recognise that theoretically, the judge at trial might find that the relevant date of knowledge is a date that neither party has positively advanced. I quite accept that. But the point I make in relation to that issue is a different one, which is that in the context of an application to amend, where the court is concerned with with whether the defendant's limitation defense will be prejudiced by relation back, the court should not have to speculate as to the entire conceivable range of alternative limitation expiries that might be out there, if I can put it that way. Take the current example. I mean, this is a case where they say, at the very latest, time expired in February 2009, long before the claim was begun. We say not until March 2018. There are obviously a whole range of possibilities in between, some of which you may have been pointed to by in my learned friend's chronology, because we've picked up on some dates to try to be informative to the court as to what this litigation is about. For all we know, if we dug really deep, there could be a whole range of other possibilities. We don't know. Now, the question that arises in my submission is this. In the interlocutory context, where the court is considering this issue, where obviously the defendant is perfectly well able to conceive of and articulate what its believed limitation defenses to be, should the court, and is also able to provide evidence in relation to that if it so wishes, including evidence of expert or foreign law, should the court go beyond that and start to speculate as to all kinds of other possibilities? And in my respectful submission, a question arises as to, well, when should the court do that? And in my respectful submission, the court should not do that unless either the claimants, for example, have put forward an alternative limitation case, or alternatively, it is readily apparent from the material before the court that that other possibility is realistic. But forgive me.
Can I frame it slightly differently? One might get, I forget exactly how different judges have expressed themselves, but one might get from the authorities an idea that you should not allow amendment unless the claimant shows that there is no reasonable possibility of a relevant limitation defence existing. Now, in that context, as I think you're sort of agreeing, there's no particular reason for the judge to be tied simply to what's said in the defence. And in this particular situation, we see that the date of relevant knowledge matters, and we see that the parties have taken two positions at either end of a scale, if that's, maybe there isn't a scale, but you're sort of accepting there might be a range of possibilities. Now, is then the right question, have you shown that there is no reasonable possibility of relevant knowledge arising between whatever it is, the date in 2016 and the date in 2017?
Well, in my respectful submission, it's not necessarily so much a question of burden. I mean, I'm not sure that much, in a sense, turns on the burden in this respect. The real question is, well, what standard of material, or if I can, perhaps a standard of proof, if you will, should be sufficient for this purpose, for the court to conclude that there is, as it were, a sufficient risk of prejudice that the discretion to amend should be exercised by refusing the amendment. I think in a sense that is the question that your lordship is raising. And in my respectful submission, the court should not be modulating its discretion by reference to anything other than a real and substantial risk of prejudice in the manner suggested. That is obviously demonstrated in a case where the pleaded defense of the defendant will clearly be prejudiced by relation back. But I am prepared to accept that in certain cases, even if perhaps for tactical reasons, shall we say, a defendant may not actually want to spell out an obvious alternative, if it is nevertheless sufficiently obvious, the court could potentially take the view that that is sufficient as a source of risk of prejudice, which would of course become actual prejudice depending on, as it were retrospectively, depending upon the findings of trial, which is sufficient a reason to refuse amendment. But the court must still have some material before it to reach that conclusion. And
I follow that.
yes.
But I don't know why the test should be anything more than a real possibility. What's the injustice to a claimant in setting the test that low?
Well, I think the injustice in a case such as the present is that obviously the defendants have raised the point about disallowing pre-service amendments very late, and they raised it, in fact, for the first time in June 2021, at a time when our case on limitation, at least one of our alternative cases on limitation, had expired.
And I see that there may be all sorts of arguments on the particular facts, but A, in terms of disallowing, well, CPR 17 says you're supposed to do it quickly.
Yes.
But B, thinking more generally,
Yes.
well, a claimant always has an alternative remedy, which is just to issue another claim form. If they think there's any reasonable possibility of this being a problem, they just issue another claim form. So why should the court say, in circumstances where there is a reasonable possibility of limitation mattering, that isn't enough?
Well, I think it has to be a reasonable possibility of the limitation defense being deprived or being, as it were, negated by relation back.
And if we get this far, then we're accepting that, I think.
Yes, I entirely agree that if the court were satisfied on the facts of this case, that there's a real risk of the defendant's limitation defense being negated by relation back, then that would be a powerful reason for at least not allowing the amendments to stand without terms. I'll come back to the MasterCard point in a moment.
Part of the problem seems to be we spent a lot of time today arguing about the test, the words. The real question is, how do you decide who, to use completely neutral words, should be stuck with the fact? Should it be you or should it be them? And it seems to me that you're saying, well, you've got to, as a court, work on something. And the only thing you've got at the moment is all the pleadings. And Mr. Kennedy was saying, I think he said to me that none of the pleadings, including the reply, crossed the relevant magic dates when there would be a problem. But he says, life is complicated, and when you're dealing with something like knowledge in the context of antitrust law and cartels who don't necessarily broadcast what they're doing, you can't be sure that something wouldn't emerge as to knowledge. And therefore, he says, you've got to do a wider assessment or evaluation based on the nature of the case and the context and so on. And given that you could have issued a new claim form, what's wrong with that argument? Why is it only the pleadings that we look at?
Well, the pleadings, in my respectful submission, must clearly be the starting point of the analysis. I mean,
Yes, I accept that.
and
We've gone through the pleadings and they, unless I misunderstood Mr.
Yes.
Kennedy, none of the pleadings conclusively help on the question of are they going to suffer? The
Yes.
problem is, given the nature of the case and its knowledge or relevant knowledge,
Yes.
in a cartel context with antitrust allegations, there is the prospect that a different date might emerge on trial.
yes, but the only alternative date that matters for present purposes is whether there is an alternative date between
It's a narrow window.
27th, because this is the point in a way. We're debating now potential prejudice by reference to a very narrow window between the 27th of September 2016 and either in respect of the bulk of the amendments, I think 1,300 out of the 1,400 happened on the 22nd of November 2019, so that therefore the inquiry in relation to them is whether there's an alternative limitation case of limitation expiry between 27th September 2016 and 22nd of November 2016.
Say expiry, you mean accrual?
Forgive me, accrual, exactly.
Because the expiry has to be within the window to issue of a claim form and amendment to the claim form.
Exactly, and so, but it has to be a commensurate accrual, if I can put it that way, 3
Yes,
years.
so there's no dispute over the 3 years.
No, exactly. There's no dispute over the 3 years, but there's no. I think there's a dispute either that the relation back, the prejudicial effect of relation back, could only arise theoretically if my learned friend could point to a realistic limitation expiry between the 27th of September 16 and the 22nd of November 16.
Or 23rd of January 2017.
Or for the 100 odd claimants who were added in January, 23rd of January 2017. But
So we can look at the pleadings to see if anything is pleaded in inverted commas that happened between those magic dates, which might give rise to a possibility. A trade decision was announced, an agreement was entered into, and so on.
yes,
So we can look at the pleadings, and we've got various things that are agreed, like the chronology. But if we get to a stage, you say, where nothing in the pleadings and nothing in the material before us suggests that something occurred between the two dates in relation to the different claims, then we would not have any basis for coming to a conclusion that there was any realistic prospect of prejudice to the defendant, because nothing will have happened to make that date the relevant date. So we can look at all the material that we've
Yes.
got to try and pinpoint something that occurred in practice rather than debating the test in the abstract.
yes, indeed. And conceptually, therefore, I can quite see that if you were troubled, for instance, by the fact that they've been able to point to, and this is the only thing they've been able to point to, obviously, no doubt a considerable amount of grey matter would have been devoted to this aspect by the defendants. The only thing they've been able to point to, the single reference to in the protestos of one of the claimants, which simply refers as a throwaway comment to the filing of the ratification by the Brazilian court of the TCCs on the 23rd of November 2016, but which was only published on the 29th of November 2016 as a possible date of knowledge. That's the only point that they have been able to identify in the massive material before you. And the point that where I was starting was, so if I can really summarize.
Yes, sorry. I blame you, of course.
No, not at all. No, it's an important aspect, and obviously it's all well and good to be clear as to the main point of principle. I entirely recognise that that's not the end of the analysis, and the court has to grapple with some of the detail on the facts. but what it boils down to in my respectful submission is really this, that it cannot be right for the court merely to speculate of its own motion, as it were, as to possibilities of limitation expiry, simply because there is a dispute, for example, as to when the cause of action accrued, or whether or when relevant knowledge was acquired. That by definition, if limitation is an issue between the parties, there could be a number of possibilities. So merely to rely on the existence of possibilities can't be a basis, a sound basis.
I don't myself see why not. We're talking about prejudice. That's your case. We're talking about potential prejudice to
Yes.
the defendant. Ex hypothesi, at the stage at which the court's considering whether to grant permission to amend, or in this case, to disallow amendments made pre-service. We don't know the answer to the limitation question, because if we knew the answer to the limitation question, we all know how it would apply. So when talking about the risk that at trial the limitation question might be answered in a particular way.
Yes.
And since what one is talking about is prejudice, the possibility, if it's a real possibility that there's a risk that the limitation might be answered in a particular way, might be thought to be enough to engage the court's reticence to allow an amendment.
Yes. I think I put it too broadly by saying one should ignore possibilities. What I really meant was
you shouldn't just speculate. You should have some basis
exactly.
for it.
There must be forgive me.
Yes. Well, can I ask you something else? We know that it's always struck me as slightly odd, but in English law, if you are a claimant and your primary limitation period for a tortious claim has expired and you are dependent on Section 14A, the onus is on you to show when you first had or should have had knowledge. That's well established to be the law. Do we know what the position is in Brazil? Are questions of the onus of proof on knowledge a matter for the Lex 4I, a matter of English law, or are they a matter for Brazilian law as part of the law of limitation, or is this just not something that has crossed anybody's radar yet? Because if the onus is on you to prove when you had knowledge, you've got hundreds of claims who might all have different dates of knowledge. Not perhaps very likely, but unless that can be eliminated, that's another complication.
Well, the short answer is I don't know what the Brazilian law position is on the onus of proof, and I don't. I can obviously foresee how arguments in an English court might go in relation to the question of the applicable law on that evidential issue, but I'm not sure that it's going to be profitable for me to embark upon that. My point, as I said earlier, is I am not suggesting that, as it were, I don't bear any onus in the sense of at least being able to make submissions and show material to you that supports my point. I think the point at the end of the day is one of substance. I accept the court is not bound by the defendant's pleading, but we agree, I think we all agree, that the defendant's pleading and articulation of its case on limitation has to occupy center stage. Certainly has to be the starting point of the analysis, not least because a defendant may not even advance a limitation defense. I mean, take obviously not these facts because limitation is more striking, but there can be many cases, or there can be some cases where at the point where an amendment is being debated, the defendant doesn't think that it has a limitation defense. But and the amendment is therefore dealt with accordingly and is allowed, and there is a relation back. But 4 or 5 months later, thinking has moved on, and suddenly the defendant thinks, well, hold on a minute, we've got a sound, or at least a reasonably arguable limitation defense, and we have to prove, and we would like to pursue it. And of course, by the time they do so, they're already faced with the limitation, the consequence of relation back. It's just too late to deal with relation back. And of course, now one might say, standing back from it, that well, somewhat unfair. But why is it? not unfair, or why is it unfairness that is sustainable as a matter of law? And that is because when the court dealt with the application to amend, it naturally can only deal with it on the basis of the case that is being advanced. Now, certainly that proposition, in my respectful submission, can't be disputed. Now, I accept, however, that that example only goes so far, because in a case where limitation has been raised prior to the court's consideration of the amendment application, it would be bizarre if the court, as it were, shut its mind to relevant possibilities. But what the relevant possibilities are, in my respectful submission, should be anchored either in what the defendant's case is, or potentially what the claimant's case is, or on the evidence before the court.
And I do see how you put it. Just talking round it again, I mean, what comes out of the pleadings is that the date of relevant knowledge is crucial.
Yes.
And although this case has been getting on for 5 years, no one's got near disclosure, presumably.
No.
And depending on how many claimants there will be disclosure potentially from masses and masses of claimants, which may or may not reveal something that would cast some doubt on the date of knowledge.
Yes.
Does that matter?
Well, this is in a sense is the key point that I want to make, and taking as an example the alternative potential date that my learned friend has pointed to, which is the date when the TCC was published. I can understand an argument that he might advance that, well, or that he could have advanced for the purposes of this hearing, and perhaps also have clarified that he would advance by way of defense. He could say, well, my clients, although we've only pleaded one alternative line of defense, we have a second alternative line of defense now. Our thinking has got sharper as a result of this appeal. Our limitation defense now is going to be in the alternative that the relevant date of knowledge is the 29th of November 2016. And in a sense, that is by implication what he's inviting the court to do. But that actually is what he's saying you should do. Now, obviously, if that is how the argument is put, I understand that. And my response to that is, well, I'm not going to make the point is he's not pleaded it because he can still amend his pleading. But I would then say, and the court then would be able to respond by looking at, well, what is the basis for that submission? I may, for example, say, well, it's not an arguable proposition because his own expert evidence says that is not a relevant date. My own, forgive me, my own expert, our own expert evidence does not identify that as a possibility. So the court is a case where the pleadings don't identify it, neither side's pleadings identify it, their experts don't identify it, but what is being said on the hoof, as it were, is, well, it's a possibility. And my point is simply this, that, well, if we proceed in this way, just by reference to mere possibilities, that's an inappropriate basis for grounding the exercise of the discretion to amend. I quite accept that the parties' pleadings may not be the end of the matter, and that if there's a sound alternative that is grounded in evidence, that is identified, that the court could take that into account. But going back to that date of the 29th of November when the TCC was published, if that is said to be the limitation defense, then my answer to that is it's not a form of prejudice in relation to the 1,300
I see that. It would only work with the smaller group.
Correct, but I mean, if the court, if we have to descend to this level where we're kind of thinking of all the possibilities, I do say that you do have to be granular in your approach. And in relation to that argument, I mean, my learned friend perhaps will think of some alternative arguments in his reply, I don't know. But certainly if that's the only one they've been able to think of for the last year or so. But if that's the point, then I say it's not an answer to the 22nd of November 2019 pre-service amendments. And as regards the January 2020 amendments, the way to achieve justice by way of preservation of that possible alternative limitation effect would be to effectively to impose a MasterCard term in relation to that cohort, so that those pre-service amendments are not disallowed, but only on the basis that they are to be taken to take effect from the 23rd of January 2020. And in relation to that point, from in terms of effective date, this is where the distinction that Lord Justice Nugee drew between an application to amend and a disallowance case comes into play, because since we were exercising a right to amend without permission of the court, in my respectful submission, the appropriate term as to effectiveness should be grounded in the date of the as of right amendment, rather than, for example, today's date when the court finally
Not a WDA type date.
or a WDA type date. So I can see that, but beyond that, in my respectful submission, for the court to start thinking of some other possible expiry date between the 27th of September 2016, sorry, I keep saying, between 27th September 2019 and the 22nd of November 2019, that, in my respectful submission, even admitting of the concept of possibilities, and real possibilities, that, in my submission, would not be a real possibility, but would be pure speculation.
Now, it's not going to be a convenient moment. We're obviously a bit adrift. I gathered from Mr. Kennelly earlier that he was confident it would all be sorted out. So I shall hope that between you, you can sort it out.
We will make it so.
Court rise available.